Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Rayleigh, in cause number 25 DCCR 1482, you're charged with the state jail felony offense of engaging in organized criminal activity, and that's from September 28th of 2025. And how do you plead to that charge?
Yes, guilty, right? Something. Right.
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I committed a misdemeanor under that.
The underlying offense is a misdemeanor assault, Judge, because it was in combination with 3 people or more. He feels it should be a misdemeanor, but Mr. Coleman and Mr. Nichols wouldn't reduce it.
And you've talked to him about what engaging in organized criminal activity means. So you've gone over all of this with Mr. Rojas, right?
A little bit, yeah.
All right, I'm going to hold the case. Y'all go talk.
Yeah.
Ask any questions you have of Mr. Rojas.
Right from the start, the judge notices that the defendant isn't completely clear about the charge he's facing. A guilty plea has to be made knowingly. So the judge slows things down. Instead of simply accepting an uncertain answer, she gives him a chance to speak with his attorney and understand exactly what the charge means. At this point, the biggest question is simple. Does he actually understand what he's pleading guilty to?
Mr. Rojas, listen carefully to his answers. He's telling you what the law is, and then we'll decide. You can decide if you want to take the deal or not, or if you want to go to trial. Good morning.
Good morning. How you doing?
I'm okay. How are you?
Pretty good.
So you're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense, and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo from them that has some unfortunate information in here about how you acted while you were there and visiting with them.
Yes, ma'am. It was over the phone, but you mean the lady was arguing and stuff. I just wanted the information on when I was supposed to meet the dude. That was it.
That's not how this reads.
They
were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
Now the situation takes a serious turn. The probation department has apparently documented behavior that concerned them enough to refuse preparing the pre-sentence report while the defendant remains on bond. That is a major problem because the report can play an important role before sentencing. The judge isn't just looking at the original offense anymore. She's also looking at how the defendant has handled the court's instructions outside the courtroom.
My bond has to be paid off.
No, that means I'm going to revoke your bond.
Okay.
And you're going to go to jail.
Okay.
And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
No,
hang on. Don't overtalk me, because that's going to show me what you're doing to them. Okay. Now it's just the time to listen.
Yes, ma'am.
All right. And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information. Okay. They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday. So
well, this is very unfortunate.
Yeah.
So you'll, but here's the thing. There's no reason for you to still not get this probation, but I don't have a choice now but to get this pre-sentence report done.
This is where the judge makes the consequence crystal clear. She is revoking the defendant's bond because, in her view, his behavior while release shows that he isn't following instructions appropriately. His personal circumstances may explain why he's frustrated or emotional, but the court is focused on accountability. And now, instead of remaining out of custody while the report is prepared, he's being sent to jail so probation can complete the process there.
So I'm going to, hang on, I'm going to revoke your bond in your case at this time. You're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report. Probably not today.
do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah, can we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah,
because do you want me to read the memo?
The whole thing. Yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just going to believe what she says, then I believe I have the right to fight on behalf of what I have to say. And we need to be able to play those phone records.
You're going to go do that. You're going to go do that pre-sentence
We're not going to play
report.
phone records today.
The
And
defendant now asks whether he can challenge the situation and even suggests taking the case to trial. But there's an important distinction here. Wanting a trial doesn't automatically cancel the consequences of what happened while he was on bond. The judge is dealing with the defendant's custody status separately from the ultimate outcome of the criminal case. So even though he wants a chance to fight, the immediate decision remains the same. He's going back to jail.
and you're going to go and hopefully be respectful and hopefully get this probation and not ruin your life over this.
Oh,
This is very-
How long do you think I'll be in
It's
there?
a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond at this time. I find it's in the best interest until sentencing that there not be a bond. You can go back with the bailiff.
And this is the bigger lesson from the courtroom exchange. The judge is making it clear that the case isn't only about the original accusation. Conduct while on bond can affect how much confidence the court has in the defendant. The defendant may believe he was simply trying to get information, but the probation department apparently saw the interaction very differently. Once the court loses confidence that someone will follow instructions, getting back that trust can become extremely difficult.